So in this video, I have a very important update in a major case against a statewide ban on the purchase and possession of magazines that hold more than 10 rounds and also their permit to purchase. So let's break down what just happened. Now, really quick before we jump into this video, I want to mention that looking at some of my analytics, about 60% of all viewers are actually not subscribed to the channel. So if you want to support the channel for free, please consider subscribing. But also another way to do that is to join the newsletter. A link will be down below. I have a newsletter available. And once we reach about 5,000 followers on the newsletter, I'm going to be doing monthly giveaways for all the newsletter members, things like optics and knives and things like that. So again, if you're interested, check out the newsletter link down below. As I mentioned in the intro, in this video, we're going to be discussing a huge win against a state magazine ban and also their permit to purchase firearms. Oregon Measure 114, which put in place a statewide permit to purchase and also a magazine ban, was recently ruled unconstitutional and struck down in its entirety. The state court judge in this case issued a permanent injunction against this measure. The state of Oregon is currently attempting to remove that permanent injunction through the appeals process. Now, this case was just heard in front of the Oregon Court of Appeals, which is now being asked to remove and reverse that permanent injunction. The case we're going to be focusing on and talking about in this video is a case called Arnold versus Kotek. In response to this measure, the Arnold versus Kotek case was filed in a state court, in a lower court, and Judge Robert Rossio, who originally reviewed this case, granted a temporary restraining order and then later also a preliminary injunction against this case. And essentially what that did is it prevented Measure 114 from even going into effect when it originally was set to go into effect. Then on review on the actual merits of the case, Judge Rossio issued his final decision and he ultimately struck down the entire measure, finding that it was invalid and did violate the Oregon state constitution. But of course, the story does not end there. Oregon then decided to appeal that decision up to the State Court of Appeals. At the same time, the state of Oregon asked for the Court of Appeals to place a stay on that permanent injunction, which was issued by Judge Rossio. But the judges there in the Court of Appeal denied that request for the stay. So that meant that that was another small win because Measure 114 was still prevented from being implemented by the state, and currently it is still blocked. But now this case has moved forward to a hearing in front of the Court of Appeals, and the Court of Appeals has heard arguments on this case, and the state of Oregon's ultimate goal is to reverse what Judge Rossio said in his decision. Now, it's important to note that since this is a state challenge under the Oregon state constitution, there is a different standard for the court here to review, and it's a different type of analysis when looking at the constitutionality because it's the constitutionality of this measure under the state constitution. Under this standard, Oregon has to apply a two-phase test. Under phase 1, there is a determination of whether or not Article 1, Section 27 of the Oregon Constitution actually applies. Under the first phase, Oregon argues that Article 1, Section 27 does not apply at all because they believe these magazines are not arms. The plaintiffs argue that that position is clearly incorrect, that these are protected arms. Now, under the second phase of the test, it's almost looking at the public's interest and balancing the claimed purpose with the potential of undue burden, aka the impacts that this would have on the constitutional right to purchase and possess firearms. This analysis battle was at the forefront of the arguments that took place in front of the Oregon Court of Appeals, and this is what they're reviewing. Now, the judges that heard this case, that heard oral arguments about the Oregon Measure 114 were Josephine Mooney, Darlene Ortega, and then Christina Hellman. Now, all of them are Democrat-appointed judges, so take that for what it is. Now, during this hearing, the arguments were focused really on what the standard of review for the Court of Appeals should be, what should they apply, whether the lower court's findings of facts need to be followed by the appellate court, and then also whether or not these magazine restrictions and the permit process here is actually a violation of the Oregon Constitution. Now, the state of Oregon argued that on appeal, the lower court decision should be reversed because this is a facial challenge, and the plaintiffs have not shown that this would not be lawful in any application. Now, this gets kind of into the nitty-gritties of a facial challenge versus a as-applies challenge. Just understand for this facial challenge here, the state of Oregon is saying that in some way, this measure is constitutional in at least some application, and therefore it should not have been struck down entirely. They also argue for the reasonableness standard, And essentially, they say that, does this measure reasonably prevent the public harm? Does the law reasonably relate to the public safety? And is the right unduly frustrated by this measure? They argue that this is reasonable in its application. It's reasonable to prevent public harm. It's reasonably relating to that public safety. And they also believe that this does not unduly burden the right to keep and bear arms. They also point out that there were fact findings by the lower court, but they argue that the appellate court here does not have to defer to any of those fact findings. They argue that under a facial challenge, the appellate court here does not have to really look at any of those records, doesn't really need to follow the evidence. They can do a de novo review, which is a fresh review of this case, and ultimately come to whatever conclusion that they want. Of course, they also argue that these magazines here are not protected arms according to the state constitution. They say that even if these were protected arms, the measure is still reasonable. It's a reasonable restriction under the Oregon precedent. Now, one of the judges asked, well, aren't these just components of a weapon? And the state of Oregon says that yes, they believe that these are just components, that these magazines that hold more than 10 rounds are just components, and that they're also not necessary for the function of a weapon. They state that there are smaller, limited capacity magazines that could be used in the alternative to have the weapon be functional, and therefore they say these magazines that hold more than 10 rounds are not necessary for the function of a weapon. Also, interestingly, the state of Oregon points to the Las Vegas incident and some of the use of bump stocks as some sort of evidence for why these types of magazines should be banned, which is interesting why they're pulling in that Las Vegas incident when it really bears not at all on what's going on with Oregon Measure 114, because Measure 114 is not restricting bump stocks, it's having a permit to purchase and then a magazine restriction. Now, during the plaintiff section of the argument, they argue that the lower court findings of fact are relevant here and should actually be accepted by the Court of Appeals because it's relevant for the constitutionality of these restrictions. The lower court developed a robust record. They've developed a lot of evidence. They gathered data and testimony about the public interest here, whether or not it would actually be served by Measure 114. And they also had a ton of police officers and police organizations that said, no, these restrictions on magazines would not actually serve this public's interest. The plaintiffs then argue that the 2-phase or the 5-step test should apply here on review. At the first phase, the court should determine, does this law apply to self-defense? And are these protected arms? The plaintiffs here, of course, say that yes, this implies self-defense and these are protected arms. And that would mean that you would then move to the second step of the phase, which really looks at a 3-part analysis. Under that test, the legislator may specifically regulate a manner of possession and also the use of protected weapons to promote public safety as long as that exercise of that authority does not unduly frustrate the right to bear arms elsewhere. And here is where the lower court Judge Ratio found that this Measure 114 does unduly burden the right to keep and bear arms because it's an outright restriction on magazine capacity, and then also creates a significant barrier for the exercise of the purchase and possession of firearms. And there's also a question about some of the timeline to get some of these permits and the potential for indefinite holds on your ability to get the permit. There's also an issue with Measure 114 because it's so overbroad and overburdensome where it's targeting every single resident in the state of Oregon. It's not just focused on claimed dangerous people or, felons in possession. It's not targeting just a specific group. Instead, it's applying broadly to everyone. The main goal of this measure is to require all people within the state of Oregon to go through the training, to go through the permit process, to be able to purchase and possess these types of items. And then also it's just a blanket ban on the purchase and possession of magazines that hold more than 10 rounds. So this was a big hearing on a statewide magazine ban and the permit requirement that's in place in the state. My general sense is that this Court of Appeals maybe wants to reverse the lower court decision, remove that permanent injunction that was put in place, remove the decision striking down all of Measure 114. If you wanted my bet on maybe what the court here is going to do, my best bet would be that they're going to try to take the easy way out, try to find that this is a facial challenge, that as a facial challenge of this measure, it's constitutional in at least some of its applications, which I don't think it is, but maybe they're going to say that in some ways this is constitutional in its applications, and therefore the lower court striking down the entire measure based on the facial analysis was incorrect, and then they would want to send it back down to Judge Ratio. Now, regardless of what happens, I think that no doubt, even if the panel here, even if the Court of Appeals finds that this needs to be reversed, this is going to get appealed up to the Oregon State Supreme Court. Now, what's interesting about that is the Oregon State Supreme Court multiple times already has not wanted to get involved in this specific issue. The state of Oregon, prior when there was TROs and preliminary injunctions, tried to get the state of Oregon Supreme Court to get involved, but the Oregon State Supreme Court deferred. They did not want to get involved and they denied emergency relief. So it's going to be interesting to see how that plays out. But now we're going to be waiting to see how the Court of Appeals rules on this critical issue. And as we get more information, I will let you guys know. So if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.